General Redding, good morning to you.
May it please the court, Catherine Redding on behalf of the state. I'd like to request 5 minutes for rebuttal, please.
Certainly.
The trial court erred when it ordered the district attorney's office to pay attorney's fees because the district attorney's office is immune from all monetary sanctions, fines, and fees under the doctrine of sovereign immunity. And before I get into the merits of the case, I'd like to just briefly remind the court of what happened. I know that you all have read the briefs, but what happened in this case was the defendant was charged with 2 counts of aggravated assault and 1 count of reckless endangerment with a deadly weapon related to a road rage incident. At trial, the victim testified about the incident, ending her summary of events with a statement that she heard 5 or 6 gunshots and that her husband then said he had been shot. Continuing her testimony, she said that a bullet was discovered inside her vehicle after the incident and that she had given the bullet to law enforcement. And it's at this point that defense counsel moved to dismiss the case because the bullet was not disclosed in discovery. During a jury out hearing, the victim clarified that that a mechanic found that bullet in her vehicle and that she had handed it over to the Monroe County Sheriff's Office. An officer from the Sheriff's Office said he was the one who had received the bullet. The trial court found that the state had violated Rule 16 of the Tennessee Rules of Criminal Procedure and declared a mistrial. The following day, the state informed the court that actually 2 bullets were recovered from the victim's vehicle. A few months later, the trial court held a hearing to further address the discovery violation. It's at that hearing where the prosecutor said that the bullets had not been listed on any reports or that had been provided to the district attorney's office or defense counsel during the initial part of the litigation. And as a result, she did not include the bullets on her Rule 12D2 notice of trial evidence. At some point before trial, though, she was made aware of the bullets, and then she failed to update that notice. The trial court ultimately entered a written order imposing sanctions on the district attorney's office, said that the defendant had suffered prejudice by the late disclosure, the state was to be held accountable, so the state had to pay for expert ballistics testing of the bullets and the defendant's gun, and was further ordered to pay attorney's fees to defense counsel in the amount of $500 for fees related to post-mistrial hearings. And then the state filed a Rule 9. The trial court held a hearing on the matter. At that hearing, the parties actually dismissed the case, and the court did not, however, rescind its sanctions order, and we are here today on that
General,
sanctions order.
You mentioned that the assistant DA became aware of the failure to list the evidence, became aware of the evidence but did not update it. What was the reason for that?
My understanding from the record, and there's information that the prosecutor provided at one of the hearings, I believe it's volume 3 of the record. She said that the original investigating officer's file, he left law enforcement, and when he left, his file could not be found. But there were some discussion, and she had not been the original prosecutor on the case. So the original prosecutor and the original officer both were no longer involved, but it appears that through some discussions with an attorney in her office, she was made aware of the bullets. So she didn't have any reports, but she did have information about the bullets. And it is clear that she had that before trial, and it is clear that she should have put that in her notice of trial evidence.
Did the trial court make any kind of finding as to a level of culpability for the omission?
My recollection is, well, the court said that this, I believe, was the most egregious discovery violation she had seen in her time on the bench. But I don't recall, at least not in the order, I don't believe that there is a finding of
intentional withholding or?
Pardon?
No finding of intentional withholding?
I don't believe so.
Okay.
I think it was simply an egregious oversight. But nevertheless, this sanctions order sanctioned the district attorney's office, not the prosecutor, and it lives despite the dismissal of the underlying criminal case.
Redding, can I apologize for interrupting you again. You said sanctions against the district attorney's office. One of the things I'm curious about reading through the record is exactly what is this? Because the trial court used the word sanctions, fines, attorney's fees. At one point, the trial court said contribution, and the written order just says the state of Tennessee pays it. So is it the district attorney's office for that district that's being assessed? It wasn't clear to me from the record. I think that's the assumption, that it's the district attorney's office for that district, but it's not clear. It just says the state of Tennessee. So I'm wondering, what exactly was the trial court ordering? Fines, attorney's fees, or some voluntary contribution, and who was responsible? Was it that particular DA's office?
My reading of the order, which the court prepared, is that it is payment of attorney's fees, and obviously the ballistics testing, paying for that, and that it was directing the district attorney's office to pay it. I mean, it's clear that it wasn't the individual prosecutor. Certainly this order did not name her specifically, so I think that the reasonable read of this order is that the state, the district attorney's office, is required to pay.
What was the, this is what I took from Judge Sword's question, though. What was the source of the authority that the trial court indicated? Was it Rule 16's sanctions rule? Was it inherent power of the court? Was it something else?
And that is the part of the problem that the state sees with this order, is that the trial court did not identify the legal basis for its ruling. It didn't cite any legal authority for this fee sanction in its order, and it's the state's position that there is no authority that allows the trial court to do what it did here. And perhaps that is, I cannot tell you why the trial court didn't cite any authority, but as we stand here today, the court didn't cite any authority, and it's the state's position that there is no authority, so there couldn't have been anything to cite. And first, and as an initial matter, as a state institution, the district attorney's office is protected by sovereign immunity. This shields the government from paying sanctions, fines, or fees unless the legislature has removed immunity by statute or consent. And there is no statutory provision or other authority that removes the state's immunity under these circumstances. And there is case law that says that courts cannot abrogate sovereign immunity of the government on their own accord. And this court has not dealt with this, but this has come up in the Court of Appeals a few times. But what is clear from the case law is that the government is protected in these kind of situations by sovereign immunity. There has to be a statute or something explicit that says that the state can be required to pay these fees or sanctions, and there is nothing here. There is no law that would allow the trial court to impose this. The legislature has not opened the door for district attorneys' offices to be sanctioned in this kind of scenario.
So what's the remedy here? So if you were to assume, not in this case, but if you were to assume that an assistant district attorney purposefully withheld identification of information that would have been responsive, let's say, to a Rule 16 request, simply just intentionally didn't do so, the state later dismisses the case. So a possible dismissal under Rule 16 is off the table. What's the remedy?
I think that the case law allows for a trial court to find that a prosecutor and the prosecutor
Right.
acted in contempt of a discovery order, and then find a contempt conviction and then impose a sanction or fee. And this was not discussed in the briefs, but I did find a case where this is discussed.
Sure. So the contempt authority was what I was thinking of too, but you limited it a little bit, as I understand in your answer, in violation of a court order. So Rule 16 doesn't require a court order. So Rule 16 is invoked as, simply upon request of the defendant. And so if the defendant makes the request, but the assistant DA, once again, it's not this case, I'm not suggesting it's this case, but the assistant DA purposefully withholds information that otherwise would have been responsive to the request. No one knows about it. The court hasn't put down a formal discovery order. Is the court without any authority then to address what appears to be an egregious violation of the rules?
I would,
particularly in a case where the state later dismisses it.
I think that,
Is it a BPR complaint? Is that it?
Pardon?
Is a referral to the BPR the only other way to go?
I mean, I certainly think that a referral would be appropriate and is an option. The case law does contemplate a contempt conviction. So I suppose that there could be that perhaps a discovery order is not necessary. But what the case law of this court says is that in order for a prosecutor to be sanctioned with a fee for a discovery violation under Rule 16, there has to be a contempt conviction. And it can't come up as a violation of the order. It has to actually be a contempt conviction.
Right.
And this court said that Rule 16 on its own doesn't provide a basis for monetary sanctions against a prosecutor absent that contempt conviction. And I'll just, for the record, this
Sure.
is in Reed Zimmerman, 1986, WL 8586, where a trial court did sanction a prosecutor it was a monetary sanction for a discovery violation. And it came up on appeal, and this court said, well, there's no contempt conviction. And without that contempt conviction, we can't uphold this. And it said, well, we can't also just kind of convert what happened into a contempt conviction. The trial court actually has to find the prosecutor in contempt. So this is not a situation where a defendant is provided no remedy. It's simply that the remedy the trial court imposed was not permissible.
Well, there would be no remedy favoring the defendant, true, right? I mean, the BPR referral wouldn't be favoring a defendant. The contempt sanction, to the extent that one's imposed, is not something that favors the defendant. I guess we're not looking really at something under Rule 16 anyway that favors a defendant. Is to remove prejudice, my guess is.
I mean, I think that the trial court could have dismissed the case, and I certainly think that that would benefit the defendant. And I mean, in this situation, the dismissal did occur, not as the remedy, but the defendant here received a mistrial and then this payment of his attorney's fees. That was the remedy that the court imposed, and it's the state's position that the only appropriate part of that remedy was the mistrial. We're not challenging that order here.
Did the trial court judge make a BPR referral?
That's not in the record. And there's nothing in the record regarding a referral. There's no statements by the court to that effect, and certainly no documentation as far as I am aware. And I think I've covered the state's argument that Rule 16 does not provide for this type of remedy. And I just briefly address the defendant's argument that the court could have imposed sanctions because he was indigent. And the court had the ability to authorize payment from the Indigent Defense Fund. But here, I mean, that just simply wasn't the basis for the trial court's order. There was never a finding, and never an order for these payments to come from the Indigent Defense Fund. It just said the state must pay this. And I mean, it's actually unclear whether the defendant is indigent just from the record. Certainly the trial court contemplated his indigency, but there's no indication that the court actually determined that he was indigent in accordance with the statute so that he could access that. But even still, the fact that there is a pool of money that theoretically could be accessed does not mean that the order imposing the fees as the kind of remedy for this discovery violation was proper. If there are no further questions, the state will.
Actually, I'm
yes.
sorry, Mr. Attorney. As I recall from the record, the trial court never ruled on the subsequent argument from the state that sovereign immunity prohibited the court from ordering the $500 fine, fee, assessment, whatever you're going to call it. Before the case was dismissed, why didn't the prosecutor get clarification on that? Say, Judge, if we dismiss this, is your order going to be gone? Do you agree with our argument that you can't assess it? It just wasn't addressed.
That is, the continuing validity of the order was not specifically discussed. I mean, certainly after the trial court put down its oral ruling of sanctions, the state filed a motion to reconsider. Then the trial court put down its a written order, reiterating, and the state filed a Rule 9. No, it was never discussed. Certainly, the issue was brought to the trial court's attention. The trial court just simply didn't rule on the motion to reconsider, and then at the hearing on the Rule 9, it was dismissed, and cannot, the transcript of the Rule 9 hearing, such as it was, does not, to my recollection, reveal a discussion of this. I'll point out that the prosecutor who appeared at the Rule 9 hearing, I do not believe was the same. Certainly was not the prosecutor who was responsible for the discovery violation, but I think there was another prosecutor. I think this was the third prosecutor. So I don't know if that was an oversight, but it's the state's position that that does not have it doesn't have an effect. The state raised the issue in the trial court for the trial court's consideration. The order is not, there's nothing in the order that makes it void based on the dismissal of the charges.
Thank you, Joan.
I will cede the podium. Thank you.
Charlie, good morning to you.
Your Honor, let me correct some misstatements about the record, and they are not Ms. Redding's fault. They are what Ms. Redding doesn't understand about what went on in the trial court. And one of the reasons why Ms. Redding doesn't understand that is because this record is incomplete. The state did not include the hearings that were held on August the 31st, in which, although they are referenced in later pleadings, the assistant DA who prosecuted this case admitted that she had this information on the Thursday prior to trial. This case was set for trial and started for trial on a Wednesday. In Monroe County, there is always a docket call of cases for trial on the Monday before that Wednesday. So on Thursday, she had this information. She did not disclose it on Friday, on Saturday, on Sunday, on Monday, when we had a docket call to see whether this case was ready for trial, and did not disclose it on Tuesday or Wednesday. It is included in this record, my opening statement, which clearly says that they had no evidence of any bullets. Yet the state intended in their direct examination of their first witness to introduce this bullet. Now, the state says, well, they're going to blame it on somebody else. And one of the reasons why the record wasn't developed is because the state knew all this information and they didn't develop this information in the trial court. The officer who was in charge of this information had given his file to the DA's office. The copy of the sheet that is filed as an exhibit to the proceedings that were held on August the 30th refers to his certifying that he has given the complete record to the DA's office. It was only after that date that he was fired or quit because he was caught perjuring himself during the course of a trial before Judge Freiberg. So we are faced with an officer who's done that, and then the state brings in another officer to say, well, I got this information. If you look at the record and the dates from that other officer, that's prior to the preliminary hearing that was held on this case, that they had that information and it wasn't disclosed. Then also, and it's referred to in the statements, but we don't have the exhibit that includes the August the 31st hearing, in which the state admitted not only did they not disclose this and had this information on that Thursday, but that they had another bullet that was disclosed to them 47 days prior to our hearing and was never disclosed. And that was disclosed directly to the district attorney's office, and the district attorney's office to this day continues to refuse to give the name of the person to whom that was disclosed, despite our multiple requests that are reflected throughout this record.
Has there been a referral of the assistant DA to the Board of
Did we make a referral? No, Your Honor.
Did anyone make a referral?
I am not aware of any referral that was ever made.
Did the trial court consider holding the assistant district attorney in contempt of
There
court?
was no discussion of contempt of this assistant DA, Your Honor.
Are you aware of a case, Mr. Jolly, where a trial court has held a district attorney's office liable for monetary sanctions?
No, Your Honor.
To ask maybe the question.
And here, and if I might address the court's question, at page, on volume 2, page 49 through 55, the court refers to what its basis for its ruling is. And if you read this record, you've got to understand that the written ruling was drafted by the assistant DA who did this conduct and then signed by the judge.
What was the authority the trial court used to justify the sanction?
She said, to make Mr. Ferguson whole for this failure to disclose and divulge these bullets.
Was that
Which, Your Honor,
was that a Rule 16?
The way we read it is that's a discovery sanction. And the way we read it is that if there hadn't been this discovery sanction, that the court might not have been considering going further with this trial, but that she felt that this was the appropriate sanction for, as she put it, the most egregious behavior that she had seen in her 39 years of practice.
Mr. Johnley, would you agree that the state district attorney's office has sovereign immunity against
Under some circumstances, Your Honor.
against claims
And
for
if I might
monetary relief?
refer to why I don't think it's there. The law is clear that an individual who violates the Constitution and is a state employee does not have sovereign immunity.
I mean, 1983?
Excuse me?
Are you referring to Section 1983?
Under 1983, but also, Your Honor, if you might refer.
But that's a completely different, Mr. Jolly, that's a completely different line of analysis for sovereign immunity. That's a congressional enactment.
Your Honor,
Where here has the state waived sovereign immunity for a?
Cornelius versus McWilliams, Your Honor.
Okay.
Former Court of Criminal Appeals judge sued for salary against the then Secretary for the Supreme Court. And it's at 641 Southwest 2nd, 508. In that case, the court held that the reliance by the defense, that is, the people who were not paying Judge Cornelius's salary, was based on an unconstitutional act, and therefore there was no sovereign immunity. And it is clear in this record that the court held that this was a Brady violation. And it's a Brady violation, Your Honor, that wasn't disclosed. You know, usually when the court gets Brady violations, you're talking about post-conviction, or you're talking about prior to trial and whether there should be a continuance. Not for a Brady violation that is disclosed in the middle of trial. And so here we're faced with a situation where this is what happens, and the judge, based on the state's motion, not our motion, the state moved for a mistrial in this case, based on its own misconduct, and the judge granted it. And so we are trying to get the judge to say no. And after the judge says, no, you're wrong, I'm going to do this because of these, and I'm going to sanction the state in this way, parts 9 and 10 of its written ruling in this case, we file a motion for the court to grant a Rule 9. It is our hearing on the motion for a Rule 9 that is the last matter at the transcript when it was determined that the state would not proceed, not because we agreed to it, but because the state couldn't get their witness back because they didn't want to come back to Tennessee and be accused of being the drug dealers they were with the gun that they had.
Mr. Jolly, can I go back, please? And forgive me for this, please. What is the source of authority for waiving sovereign immunity against a DA's office in this context?
Well,
I don't understand excuse me.
Let's look at Rule 16, Your
Mr.
Honor.
Jolly, excuse me. I don't understand that the case that you cited relates to waiver of sovereign immunity against a district attorney's office. So how does that case relate to what is going on here?
The Cornelius case?
Yes, sir.
It relates because of the language that the court used, that when you rely on an unconstitutional act, you do not have sovereign immunity. And while in that case it was a legislative act, the unconstitutional act in this case is the Brady violation.
And so from where does that authority spring that a court can order a monetary sanction against a district attorney's office for a Brady violation? Is that just common law authority? I mean, where do courts get that authority?
To levy a sanction,
Against the state,
the
against the treasury of the state.
discovery rule, and I'll quote it exactly so I'm not mistaken, says for violations of discovery, that again, after there's a continuing duty to disclose, that the court may do 4 things: order the party to permit discovery, grant a continuance, prohibit the party from introducing the disclosed, or enter such other orders as it deems just under the circumstances.
So typically the rules of procedure are not substantive rules. Sometimes they may be. In this case, you believe that a rule drafted by the Supreme Court, approved by the legislature, is a waiver of sovereign immunity?
Yes.
Okay. Any case law at all to support that?
No. Because we're unique here in this circumstances.
Well,
Because
let me ask this, and I'm sorry to interrupt. How are you going to execute on the order? So your brief
I've never tried to execute.
Your brief suggested that you have not. Where do you go to execute on it?
Where do I go?
Yes.
I believe that if I were to choose to execute on the order, that I would have to go to the Board of Claims. And probably, if I remember from back in the distance, my time has run on that I can't do it even though there's an order that could be effective. And then the state says, and it looks like they admit in their brief, that they should have paid me a long time ago. But they didn't, and then maybe they're in contempt for not paying me, and that could litigate it other way. But we haven't ever asked, Your Honor. We haven't asked. We're in front of this court because the court asked us to be here, because the state, and you've got to, if you look at this record, you see a distinction between assistant DAs and who files. The state never brings up in any of the proceedings that the judge had no authority to enter this attorney fee for a sanction. They file a pleading, but it's never brought up. It's never brought to the court's attention. It's never brought to the court's attention before the state chooses to dismiss this case, before we have a chance to bring these egregious circumstances before this court.
Mr. Jolly, I assume Mr. Ferguson has not exercised his right to expunge this case at this time?
Yeah. Your Honor, I take that back. He may have. I don't remember. We've had discussions about doing that.
So does the order still exist in the trial court? Has it been destroyed?
The state was able to get it when they filed their record in this
that's true.
case, so I assume
It's still there.
that it's still there. But on the other hand, the state has the opportunity to expunge the order, and if so, maybe it doesn't ever exist. And if we've never attempted to collect on it, I'm not sure why we're here. Because my major concern is not that I get $500. It's that whatever this court rules is going to be used so that the state costs of discovery are going to be given to defense counsel, because the rules say we only have the opportunity to observe and copy. It doesn't say that the state has to provide us with a copy. And if this court orders that the district attorney's office is covered by sovereign immunity in discovery and discovery sanctions cases, then we're going to be paying money out of our pocket to obtain discovery from the state of Tennessee that the law requires them to give us. And so my concern is this. One is the state never pushed this at the trial level. Two is there's been no opportunity to collect, so I don't believe it's properly before the court on any type of immunity, because immunity is against, if I were to choose, it talks about any lawsuit against the state. There is none. There's been no request that the state pay money. Two is that this was an unconstitutional act done by an assistant DA that, in my opinion, was intentional and knowing. But my opinion's not worth a whole lot. I've just been practicing a number of years. But when you don't disclose something and you know you have it and you hide it, that to me is intentional conduct. And it's only because of what we see as the implied consent by the state to continue to prosecute Mr. Ferguson until it was finally dismissed because they didn't want to go through the process of bringing a witness who smoked marijuana back from the state of Colorado, that this was dismissed by the state. And frankly, the last time I tried to object to a dismissal, I was told, you won, get out of here. I couldn't do that. I couldn't agree to it. It's done. The state did it. Yes, I signed the judgment because it's my responsibility to make sure that that judgment says what protects Mr. Ferguson. Not to collect money, but what protects Mr. Ferguson. And yet we're in front of this court with an incomplete record, without an objection that was brought to the trial courts. If I were to come up here as a defense counsel and say, I filed a motion and the trial court never ruled on that motion, I'd be out of my ear.
Not on a question of jurisdiction, you wouldn't. And so what I understand the state to be arguing is that there is sovereign immunity against an order that compels the state treasury to pay money. That's a jurisdictional issue. It doesn't appear to me that you're arguing that the assistant DA can somehow waive sovereign immunity. I mean, in my view, I don't know that the state ever could waive sovereign immunity like that. I think they could always raise it because it's a question of jurisdiction, just as you could raise a question of jurisdiction.
My argument is just as the court may assess costs against the state of Tennessee and the procedure in criminal cases, that the rules of criminal procedure.
There are statutes that allow that, though, Mr. Jolly.
And we say that the minute the legislature approves the rules, they have the force of statute, Your Honor.
So you're saying Rule 16 is a legislative act that allows the court to issue any sanction they feel?
An official act that has been approved by the legislature, Your Honor.
So under the statute, I can't remember what the...
And if you want to argue, no, there's no specific authority given to put a monetary sanction, that's correct. But the judge thought, and nobody brought, the only question that was brought by the trial attorney to the judge's attention is, how much do you want us to pay for how many times? And the judge says, well, here it is, $500. They didn't say, we object, because their concern was they've messed up big time and they want to prosecute Mr. Ferguson. And you know, I could go off the record and talk about exercise of discretion, but I won't. This is an egregious case, and the court recognized that, and I'm here because Judge Donaghy's order setting a sanction against the state of Tennessee, be it enforced or not, is appropriate for allowing her to continue a case that was eventually dismissed. And we would ask the court to allow that order to stay in place.
Mr. Jolly, thank you very much. General, 5 minutes on rebuttal.
Your Honors, the state acknowledges that the assistant district attorney did not turn over the information. It was not disclosed before trial. The severity of the violation, however, does not mean that the state's sovereign immunity is abrogated. There is no authority to say, well, it was so bad that that itself is enough to abrogate sovereign immunity. It has to be statutory, it has to be clear. The legislature has to do this. The legislature has the responsibility to say, they're the only ones who can say, yes, the state is consenting to be sued in this, or is consenting to be sued or consents to be liable for sanctions, fees, fines in these situations. And that just simply isn't what happened here. It's the state's position that it did not have to object to the sanctions order the way in which the defendant says that the state had to. He cites case law about contemporaneous objection to the omission of evidence. That is not what we are dealing with here. It's the state's position that the motions that it filed in the trial court for the trial court's consideration were sufficient to preserve the issue for appellate review. And as this court has pointed out, it's a jurisdictional issue. So it's the state's position that this court has the authority, the jurisdiction to consider the issue that the state has brought before it.
So your friend on the other side suggests that because there's a Brady violation, constitutional violation, he says that that authorizes the court to enter a monetary sanction award against the state. Are you aware of a Brady case that recognizes monetary sanctions as a possible remedy?
No, I am not.
What are the remedies typically in a Brady violation?
Well, I think that they can exclude the evidence, dismiss the case, but there is nothing that says a monetary sanction against the district.
All remedies that were available here, right? And
Yes.
in fact, were exercised.
Yes, but there is nothing that says that a Brady violation is opens the door, abrogates sovereign immunity for a trial court to impose a monetary sanction on the district attorney's office. And again, that gets back to the legislature is the body that is responsible for this, has the sole authority to do this. Courts cannot do it on their own. And I just point out a few things. I mean, if there is an issue and the state has prepared the record that it believes accurately reflects what occurred in the trial court. Defense counsel has made some argument here today about things that he claims are not in the record. Certainly that was not raised in the briefs. And I would say, however, that the order that was the trial court entered that imposed the sanctions was not in fact prepared by the state. If the language of the order says the state drafted I think the court told the state to prepare an order that Mr. Jolly objected to some of the contents of the order, and so the court was putting down an order where it had modified the one proposed by the state. So I don't think that that's entirely correct. I mean, certainly it doesn't lay out, well, the state put this part, but I had made these changes. But as to the defendant's claim, he says that the DA's office does not have sovereign immunity because, points to 1983, but that says an individual is liable. Here we are talking about the district attorney's office. He points to Cornelius, but as we said, even if there was somehow an unconstitutional, there was an unconstitutional act, it was an unconstitutional act of the assistant district attorney, not the district attorney's office. So, or the state, the treasury of the state. And Rule 16 does not abrogate sovereign immunity. And the case law is very clear. It says that any abrogation of the state's immunity must be entirely clear. The statutory power to assess costs against the state is in derogation of the state's sovereign immunity and must be strictly construed. Rule 16 does not explicitly lay out an abrogation of sovereign immunity of the state in situations where there is a discovery violation. Certainly courts can order individual assistant district attorneys to pay, but the issue is that that's not what the court did here. The court ordered the DA's office, which is different from the ADA. And I just point out that this order does not say that it goes into effect when Mr. Jolly or the defendant in his individual capacity attempts to get this money. The court's order says the state shall pay this fine. So the fact that Mr. Jolly has not taken any steps really does not have any bearing on the issues before this court. So if there
Very
are
good.
no further questions, the state asks this court to reverse the trial court sanction order.
Very good. General, thank you very much. Thank you both to the parties. Well presented and well argued. Thank you. Call the next case, please.